Need to have a will. Um, Subhanallah, one of the biggest questions that I get after Jum'ah or in fundraisings is, Brother Khalid, if something should happen to me and I don't have a will the government or the state take all my property? We'll answer that here in a second. The second thing we get at the office is a call from loved ones of a deceased that the brother or the sister, mostly the brother, has passed, and some members of his family want to cremate the body or have a church service or non-Islamic burial. And this is important in this topic. We'll address that, how to avoid all that problem. The third major thing that we get with regards to wills is the call after somebody passes and the kids are worried sick because they have no idea what their father left behind in terms of debts, assets, properties, bank accounts, and they have to come hire lawyers and investigators and look for what their father or mother left behind. All of these things are addressed with a free will that you can get from the office, or we could email to you that you don't need a lawyer, you fill it out and you can address all of these problems. Now, the way we would like to start, okay, dying without a will. Is that me? My name is Khalid Hamideh, alhamdulillah. I'm an attorney for the last 35 years and pro bono counsel to ICI. Pro bono means free, free of charge, for sabilillah, in the sake of Allah. This is my son, Yusuf, who's also an attorney. He will address the first part, and then all of these questions that we have in the community, I will address as well. So, Yusuf. Thank you.
Assalamu alaikum wa rahmatullah. Can we go back a few slides? So we're going to begin by just going over a few words that everyone should know, just so everyone understands what we're talking about. So the first one being a decedent. A decedent is the person that passes away. And it's simple as that. The person we're talking about for a will, the person that we're talking about whether has a will or does not have a will, so the person is called a decedent. And then what we're talking about is a will. And all a will is a document that is legal and binding that allows you to do the things that you want to do to protect your loved ones after we all pass away. And the importance of why we're here today, Taban, is as we all know as brothers and sisters of Islam, no one knows when our time is going to come. So it's best to protect, it's not for ourselves, but for the future, for our children, for our loved ones, to make sure that everything is in place before we pass away, again, which we don't know when it will be. So it's best to do it as soon as possible. And then the estate is everything that the person owns, the decedent. The person that passes away, it's their estate. All the assets, all the debts, all the property, everything is called the estate of that individual. We can go to the next. And the beneficiaries are the people that will benefit from either the will, or if you go through intestacy, which we will talk about later, all the beneficiaries are your loved ones, whether it's your spouse that survives, your children, grandchildren, brothers, sisters, those are known as beneficiaries. And an executor is an individual that you name in the will. An executor executes the will. And what that means is there's certain duties that need to be done. So when someone passes away, like my father was just explaining, what's very important to do is inventory the estate. What that means is to find all the property that is owned, cars, real estate, bank accounts, insurance policies, whatever it is, everything, they need to inventory, find it, list it. That's just one of the things. Pay the debts of the decedent. Distribute to the beneficiaries. There's many things that an executor does. If you draft a will, you can name who you want it to be. Whether that's a brother, older son, surviving spouse, it doesn't matter who it is. An administrator is if you die without a will, the court will appoint someone to do the things that we just stated. Whether you died with or without a will, these things need to be done. So an administrator, a court appoints, and there's certain differences between an executor and administrator that we will go over. So as I just stated, intestacy or intestate is when someone dies without a will. Now, brothers and sisters, why we're doing this today is to show why it's so important to have a will. When you have a will, you get to choose exactly how you want things done. When you do not have a will, all of your assets, everything you own, there's certain rules in the state of Texas. This is what's going to happen. Whether you're Muslim, non-Muslim, white, black, doesn't matter. If you die without a will, exactly these certain things are what's going to happen. So we can go ahead. And these are just a few examples. Like everything in the law, everything has exceptions. Everything is more detailed than needs to be. But these are just some examples of what would happen if one dies without a will and all of their assets have to go through intestacy. So the first one we have is a married person with children, and we're talking about a decedent's separate personal property. So without going into too much detail, there's two different types of property. There's community property and there's separate property. Separate property is all the property owned, and if, like I said before, there's exceptions to everything. So what we're talking about today is all general. If we wanted to go into the exceptions, we'd be talking all night. So separate property, anything you owned prior to the marriage. If you bought a car and then you got married a year later, that property, that car is separate property. If you got married and then you bought a car, that would be community property. So community property is the exact opposite. Anything, you make money, you open a bank account, buy a car, buy a house during the marriage, that's known as community property. Exceptions to that, without going into too much detail, is inheritance. If you're married and your mother, father passed away and they leave you whatever it is, inheritance, that will remain separate property. A gift, if your father buys you a car, even if you're married, that remains separate property. So without going into too much detail, that's the difference between separate community property. Now we have personal property and real property. And that's simple. Real property is real estate, land, and personal property is everything else. So in this example, so if someone dies without a will, all of their separate personal property is going to be distributed exactly as it shows there. 1/3 to the surviving spouse, 2/3 to the children. Again, regardless of what they wanted to do with the property, this is what's going to happen. And if we're talking about real property, this is where it gets more confusing. The surviving spouse retains a 1/3 life estate, and we won't go into too much detail about that. A life estate means the surviving spouse retains the right to the property, but they cannot sell the property. Once they pass, the children own equally all of the real property of that individual. And then we have decedent's share of community property. And as you can see, all of the surviving spouse retains that. And these are just more examples. You can go to the next slide. Even more examples, decedent's separate personal property all goes to the surviving spouse. And even more examples. So you can keep going to the next slide. And even more examples. So again, brothers and sisters, the reason why we're here to talk to you guys today is that intestacy, this is what's going to happen if you don't have a will. Regardless of what you want to happen, this is what's going to happen. And hopefully each of us will have a will when we pass. And my father will talk to you about what the Islamic wills that everyone is wanting to know and whether they're valid in Texas and all of that. Let's see, is there anything? Okay, so as we spoke about for administration of a intestate, there's two separate things, and this is something else. There's a dependent administrator and an independent administrator. As it states, dependent is they're dependent on the courts, meaning all of the things that we said an administrator needs to do, whether that's inventory, pay the distributees, the beneficiaries, file a lawsuit upon the estate. Dependent means that they will not be able to do anything on their own. Everything that they do, they need to go to the court. The court has to sign off on that, say it's okay, and then they will allow this to happen. This, just as it says, takes more time and more money. Independent, the next slide, is the exact opposite. Is if the court allows one to be an independent administrator, it means that they are allowed to do these things without the court intervening, without having to go to the court every time and have the judge say, okay, that is fine. So independent, doesn't take as much time, does not take as much money. But either way, one is needed, either dependent or independent, when you're going through intestacy. And my father is now going to speak to you about testate or dying with a valid will. Do you want to answer questions now or at the end? At the end, if that's okay. Yes, yes.
We'll do all
Just
the
hold on
questions.
to it.
You'll have a lot of questions when we're done. All right. Why do you need a will? You need a will because you don't have to come to a lawyer. If your kids and wife, if you don't have a will, your kids and wife have to go to a lawyer because you're going to go through probate. All right. I'm going to simplify everything and hopefully clear it up. Death happens in Texas. You either have a will, your will controls everything, or you have no will, the statute controls everything. SubhanAllah, the statute isn't that far removed from the Islamic distribution schedule. Wife, kids, mother, father, children, brothers, sisters, aunts, and uncles. But if you die with a will, what's the benefits? You get to control how you are buried. You get to control who buries you. You get to control where you're buried, how you're washed, where you're washed, all of that. You die without a will, your family is left to think about what you would have wanted. You die with a will, you appoint who you want to take care of the three most important things that you put in a will. The executor, the person that takes care of your last wishes. The trustee, the person that takes care of your money until your kids reach the age of 18, or you can make it 20, you can make it 25. You can custom make the trust to be any age you want. And the third thing is the guardian, the person that will raise your kids if they're under 18. And in any will, you always put three names for backups, because a person may die before you, a person may move, a person may not want to serve. The second benefit of having a will is you can choose to have your executor to be independent of any court action. In other words, they don't have to go to court to ask permission from a judge to do anything. They can do it based upon that you trust them. You trust them, you appoint them, and they don't have to put up a bond. If your executor or administrator is dependent, they must put up a bond, an insurance policy, saying that they will honor your wishes. That bond costs money, has to go through probate. Probate needs a lawyer, that costs money. You can avoid all of that if you have a will and you have an independent executor in your will. Then finally, you get to control the distribution of all your property. You get to control if you want to give a gift to charity. You get to control if you want your jewelry or your car or your clothes to go to a certain person. As we know in Islam, you can gift away a third of your property under Sharia, and you can gift it in your will. You can give it to an institution, you can give it to a person. That's a benefit you get if you have a written will. What does it take to have, what are the legal requirements to have a will in Texas? Has to be in writing, has to be signed, has to be witnessed by two people, and if you have an independent administrator, has to be notarized. Not very difficult at all. Okay, I'm not close to a computer, I'm not close to a lawyer. You handwrite it, and you have two witnesses. Texas recognizes a valid will. As long as you put in there what you want, who your executor is, trustees and guardians. You don't have kids under the age of 18, you don't have to have guardians, you don't have to have a trust. You just have the distribution of your schedule. Can I just say I want everything distributed pursuant to the Islamic distribution schedule, approved by INT, approved by ESNA, approved by the Islamic Center of Irving? Absolutely. There's an Islamic will that we've developed, free of charge, and anybody who wants a copy, This is not a promotion for me to get work. Alhamdulillah, I have more work than I can handle. This is a community service for the community. Anybody who wants a blank form of the Islamic will with the Islamic distribution schedule, I'm happy to provide it for free. All you have to do is fill it in. Fill in the names of the 3 people, fill in the names of your kids, sign, have 2 witnesses sign, all 3 of you sign in front of a notary. You have the original, make a couple of copies for your administrators, 100% legal. Approved, will relieve your heirs from all of the problems that Yusuf was talking about, not knowing where everything will go, how to be buried. Remember the 3 things that our community has suffered from. You know, that call that, you know, they want to cremate the body. If you have a will, Islamic will or otherwise, and you say, I want to be buried wherever, in Joshua or Restland or Farmersville, khalas, it's over. Or I have purchased a lot in so-and-so cemetery. Khalas, it's over. I want to be buried in our form of the Islamic will. It says, I want to be washed, wrapped in a white cloth, my face facing Mecca, and I don't want any non-Islamic rituals to be conducted upon me upon my death. Valid. These are your last rights, your last wishes. They are honored under the law and they are approved. So you take care of that problem. All right. The kids that don't know where everything else, like Yusuf was saying, when you have a will, you just inventory. My property is, and nobody gets to see it but you. And the other people get to see it, the beneficiaries, the administrators, they get to see it upon your death. You inventory, this is and it's a good practice to have. Every 5 years, every 10 years. This is the property I have. These are the people I owe money to. This is when I promise to pay them. All right, let's say I'm traveling. I'm going to Hajj, and I'm in Mecca, and I think of something, or I get sick, and I wanna amend my will. Very simple. Get out a piece of paper. You write your name, you write the date, you write what you want to amend, and you sign it. As long as it's in your handwriting, it's dated and signed, it's a valid amendment to your will. Texas probate is very simple. It's very easy as long as we just follow the rules. It's called a codicil. You can amend your will anytime during your lifetime. What do you have to have a valid will and a valid codicil? Is you have to be in control. It's not something to where somebody is putting undue influence on you. Oh, I want to get rid of all of my beneficiaries. I want to give it to my new wife. And then there'll be questions. Did he have testamentary capacity? Testamentary capacity means that you just freely wrote the will. If there's no question about testamentary capacity, then the will is honored and obeyed. Those are the main issues we have with wills. Wills in Texas are very simple. Are we still going? Okay. I'm just going off on any way I want. Was I supposed to follow that? All right. Yes, Islamic wills under Texas law are valid. So you can have a will and have the Islamic distribution schedule. Can I have a simple Texas will and say, I want to give this person this? Absolutely. And then we'll always have the question, if I have, God forbid, if I have 3 sons and one of them dies within my lifetime, do I want their kids to take? Most of us say yes. And you can address that in your will. If I have, if I have a second wife, do I want the first wife to take anything? You can address that in your will. All of those things, as long as they're set out clearly, absolutely enforceable, absolutely valid. All right. From what I know, the Quran prescribes upon us to at least be clear and to have a will and not to put our beneficiaries in any kind of hardship after we pass. Make it easy upon them. So, all right. So finally, quickly, the benefits of having a will. You can have the orderly transfer. I almost forgot the most important part. One of the main reasons to have a will is taxes. You want to avoid probate tax. The harshest tax under our law is probate tax. It's harshest meaning the highest. It's 40% of your estate. Now, When I started practicing law in 1987, the exemption is you get a certain amount, and above that you get taxed at 40%. When I started practicing, it was $400,000. Now, the most simple house is $400,000. Now it's $11.2 million. So if you are married, it's almost $22.5 million, which is good. If your estate is going to reach anywhere near that, then you need to get into estate planning. You need to get a lawyer, set up a pour-over trust to make sure your property doesn't go through probate. It goes directly to your kids, and you can set up a family limited partnership. You can set up a trust. All that can be handled. Most of us are going to be under the exemption amount. The second thing is, a lot of people before their death, they decide, I'm going to be smarter than the government. I'm going to gift everything to my kids. Well, in 1916, Congress figured out that the rich people were just giving everything to their kids, so they enacted a gift tax. Guess what? The gift, we have the chart, right? Oh, I thought I put it in. Okay. The gift tax is, guess what? 40%. You gift more than $10,000 to anyone, you're supposed to report it. Above $10,000, you're taxed at 40%. So smart people decided to do what? Okay, I'm not going to give it to my kids. I'm going to give it to my grandkids. So Congress passed what? The generation skipping tax, 40%. Now, no politics, but when Republicans took over, they allowed a new law to come in which said, hey, anytime during your lifetime you want to give a gift up to $5 million to anyone you want, even your kids. So now there's an exemption. Like Yusuf said, there's an exception to each exception. So during your lifetime, if you wanted to, you can make a one-time lifetime gift of $5 million to anyone you want, including your kids. So the main reason to have a will is if you have any inclination that your property, you buy a house and it goes up, 20 times, and you buy whatever, an investment property, or you create something and now it's worth $100 million, then having a will and having an estate plan means you won't have to go through probate taxes. The other benefit of having a will is you don't have to come to lawyers. If you have a will and you have an independent executor, it's like giving someone a power of attorney. One of the other issues we have in our community is somebody dies and they either have a bad will that's not written right, or they don't have a will, and the kids can't get into the bank account or the safe deposit box. If you have a will with an independent executor, they can go in. It's like a power of attorney. They can go into the bank. They can go into your box. They can transfer ownership of the cars. They can do all of those things without having to go ask for permission from a probate judge. So those are the benefits of having a will. Orderly transfer of property, avoiding property taxes, not having to go through probate and paying lawyers' fees, and having certainty as to how you're going to be buried and who's going to bury you and where you're going to be buried. So those are the things that I wanted to get out to the community. Whoever wants a copy, we didn't bring hard copies, but we can email a copy of the Islamic will, the form, for free, with the Islamic distribution schedule to anyone who wants. Just make sure that I get your email. So at this point, I'm happy to answer any questions, and Yusuf can answer any questions. I'm sorry, brother, we made you wait a long time.
Let's say in the default plan, where you didn't have a will, let's say you didn't have a spouse, do your children get all of it?
If you don't have a will, yes.
2/3.
Yes.
3/3?
Yeah, that 1/3 that's supposed to go to the spouse, that all goes to the kids. If the brother is asking if you are not married but you do have kids, that 1/3 that was supposed to go to the spouse, does all your property go to your kids? Yes. Your kids, under the Texas probate distribution schedule, your kids and your wife are the main beneficiaries, as long as you have them. If you don't have a wife and you have kids, then they're the main beneficiaries. Oh, going back to the very first question I asked, does the government take all your property if you don't have a will? You would have to be the most unlucky person ever. It means you don't have a wife to take, you don't have kids, you don't have a mother. These are people that have to be alive at your death. You don't have a mother alive, a father alive. You don't have any brothers alive, any sisters alive, any uncles, aunts. If you're close to that situation, then definitely have a will, because the government may take your property. But you would have to have no descendants, no lineage, no first level descendants, mother, father, brothers, sisters, no kids, all of that. Then the government could take the property.
In most cases, wife and husband are in a mortgage with the house, right? So if I die, automatically my wife doesn't own it if I don't have a will. Similarly for the bank account, when we open an account, we always declare the beneficiary is our spouse. So in these two cases, if I don't have a will, what is going to happen to my property? Because my wife is also in the will. Also, my wife is declared beneficiary in the bank.
Good question.
Do I still need that? I mean, anything different would happen if I don't have any will?
No. When you open up a bank account with your wife, there's a section that says joint survivorship. They basically make you sign a will, but it's a joint survivorship. So therefore, if you pass, then your wife automatically has the account. Same thing with the mortgage. If you pass, then your wife automatically gets the mortgage. Sometimes, some mortgages are tricky because of what we had with all of the fake mortgages and the savings and loans fiasco. Now there's language in some mortgages that upon changing anything in the ownership, there's what's called a due on sales clause. It has to be refinanced or you have to get a new loan. So you have to be careful with the mortgage, but most of them do have what you described. If you pass, then the other spouse gets it. Yes, sir.
Someone live and die in Texas and have the will, but they have other properties in out of the state. What will be the case? Will this will be enough for the out of the state property?
You want to cover any?
Different will for that state.
Oh, and again, I went real quick, but yes, all of the property all over the world should be included. If you pass and your will goes through probate, or if you have a lot of property, even if you have an independent executor, then they'll make them go through probate. Your administrator is required to file an accounting of all your, I'm not saying you, I'm sorry, of the person who passes. The administrator is required to file an accounting and an actual federal tax return. Then they have to, at the end, when the judge approves everything, then they do what's called a determination of heirship. If there's no will, that this person died and he has 5 kids and 2 grandkids and his wife is alive, that's a court order that says these are the people that are going to be they're going to inherit. At the end, the judge signs the order, giving them their right to inherit, and then signs an order closing it. But it includes all the property, whether in Texas, New York, Pakistan, Senegal, Jordan, South Africa, includes everything, includes all the property. Because the administrator has to swear to the judge that this is an accurate accounting of all the property and all of the debt that the decedent had. Mm-hmm. Any more questions? Yes, brother. If you don't have a will and your spouse has passed, Texas law is almost not identical, but very close to Islamic law. If you have a surviving mother and father, they would. If they're not alive, if you have surviving brothers and sisters, but then they would have to apply through the probate court to get the guardianship over the kids. If you die without a will and without a spouse, but you have kids, that must go through probate. Because there has to be an official court order for them to go be registered in school, be seen by a doctor, because travel on an airplane. If they're under 18, they can't do any of that without your consent. So that court order from probate gives that person who is ever appointed, your mother, father, brother, sister. Oh, absolutely, yes. But the court has to appoint them. Yes, they have to go and apply. Oh, yes, brother. What's the question?
Can the administrator be a beneficiary as well?
No, no, that's a conflict of interest. The main thing when you appoint the people is you have to avoid conflict. You can't appoint someone that is going to distribute and also get, because they could be in a position, I'm not saying that they would be, but you don't want to get the conflict of interest that they're holding two positions they could benefit themselves. So no, you would have to appoint someone else. The three people you appoint, the executor has to be someone you trust to execute your burial and funeral the way you want. The trustees, you have to have someone that you trust take care of your kids' money until they reach age of 18. And then you can put conditions if you want, that I don't want them to take when they're 18. If you have a large estate, 18-year-old, they may or may not be mature enough to handle $1 million. So you may say, I want the trustee to keep the money invested, or keep the money in rental property, or keep the money in the stock market, or keep the money in this mutual fund. Give my kids this amount at 18. When they graduate college, this amount. When they get married, this amount, and give them the rest at 30 or 35. So you can control that. And then the guardian, obviously, is someone you trust to raise them the way you want them raised. But you want to have, and if you're married, the first person for all three could be your wife. Now, is that a conflict? It could be a conflict because she's the main beneficiary, but because she's your spouse, she should know, how you want to be buried. She should raise the kids because they're her kids. She should take care of the money because they're her kids as well. Now, some people, they appoint the spouse for the first two, but when it comes to the money, they appoint someone else, and that's fine too. But sometimes, your wife knows all your secrets, and she knows, how you would want your kids raised and how you would want the money being spent on them. Yes, sir. It only makes a difference if they can't get here. But no, it shouldn't. Like, for instance, someone dies and they have a relative in London, and he's a beneficiary. The administrator could finish everything and get them to sign documents over there and get it notarized, send it to the court, and then send them their check. So it could be done, but sometimes they have to come here for hearings if there's anything that's being contested. So for instance, bad example, but the oil man in Houston who wrote a will and said, I don't want to give anything to my wife or kids, I want to give them to my new wife, which was a lady he met, I think in a club or a bar or something, and she was like 26 and he's 85. And so all the kids came to court and contested, no, this will. So if there's no issues, they don't have to come to court, and they would just get their check in the mail or wire transfer. The court appoints them. If you don't have the benefit of having a will, you get to choose the administrator. If you don't have an administrator, the court will choose them for you. But they'll look for someone close to you. They'll look for a brother. Yeah. But if they can't find anybody, they'll probably appoint a CPA or a lawyer. And if you have a large estate, they're going to take their fee from the estate. Benefit of doing a will, you don't have to go to lawyers. You can avoid probate taxes, and you can have the certainty as to how you want things done with your funeral, burial, and distribution of all your assets. Yes, sir. Either way. Leave it at the office, and they'll give it to me all at one time. Or I can give you a piece of paper, and I don't want to burden the office. I'll give you my legal pad. Just write your email, and I'll email you the draft.
We can do that now while you finish answering questions. Yeah.
Here's a pen. I had a pen somewhere. Jazakumullah khair for listening, and if anybody. It doesn't take very long. You can do one in a day. It's just, you just have to, if you do the form that I'm going to send you, you can do it in one day, but you just need to go to a lawyer's office, a bank, or someone, just to have it signed and notarized. So you can do it in one day, but you have to think about who you want to appoint, the 3 people, and then just put the names. It's free. The one I'm going to email you to, if you have, give me your email, I'll send it to you, it's free. Doesn't cost you anything. You just fill in the blank for the 3 people that I mentioned. The executor, you put 3 names. Trustee, 3 names. Guardian, 3 names. Guardian is who's going to raise the kids. You can put your wife, you can put then your mother, brother, sister, whoever you trust to raise the kids if you and your wife are not alive. Trust is who you trust to take care of the money and give it to the kids when they're 18. And the executors, whoever you trust, and it could be the same person, to bury you and have the funeral and the burial Islamically the way you want it.
Okay. So the trust, if the kids are under the age of 18.
Yes, sir.
And then if they are over the age of 18.
Then you don't need a trust. It's not applicable to you. You don't need a trust. You just need the other 2 sections.
So I need to give them my email?
Yeah, just write it on the legal pad, and inshallah next week I'll email you the form.
And if there is any confusion, we can communicate through the email, like,
Oh, absolutely. Yeah, when you email me, I'm going to email you back. You'll have my name, my phone number, my office address, my Twitter, my Facebook. You'll have everything. Our website.
You offer consultation of what we need to be doing?
This is it. But if you have more questions, yeah, just
He has their own specific case,
Yeah, no, that's not a problem. You call me. As long as we can handle it quickly, that's fine.
Okay.
And then if it's something more complicated and you really need a full consultation, then you can go through the office and they'll give you a hard time because they want money from you. If we can handle it, it's free.
That 1/3 Islamic, that 1/3 that you can assign to somebody.
Yes, sir.
Can it be assigned to somebody that gets inheritance?
Yes,
Oh, so they could get their inheritance plus a
yes,
third? Okay,
yeah,
I didn't know.
yeah. But the 1/3, okay, we're done with this. The 1/3 is usually reserved for charity. It's for something that you want to give